I am happy to have my panel here. So let me start by introducing you all, and then we will have a discussion about influencers, disclosures, and social media around the world. So let's start by moving the slide. And going backwards, that's a great start. So let's start by introducing the panel. You've got me, I'm Melissa Steinman from Venable in the USA. We have Jose Arochi from Arochi and Lindner in Mexico. Hande from Turkey. Gunin Partners. Justina Zhang from TransAsia Lawyers in China. And Erik Ullberg from Wistrand in Sweden. So we'll get through that quickly and start the discussion because there's lots of, I'm going to stop going backward and start moving forward here. So in terms of the agenda, of course, everybody's familiar with social media, or hopefully nearly everybody at least. There's been lots of developments in terms of the technology, but countries are sort of all over the place in terms of how quickly they're developing when it comes to the laws or how they regulate social media. So with the countries we're going to be discussing today, there are a variety of different ways that we approach regulation of social media, which is going to make, of course, make this interesting this discussion interesting. We'll also be discussing some of the key cases or actions in this area, and then get a little bit more into the practical. What are best practices? What are some of the disclosures we're seeing? Some recommendations for agreements or influencer contracts. What may be restricted conduct or hot topics that you should watch for or stay away from, and then some additional practical considerations when you're running a multi-country or global campaign. And I went forward that time, so already we're going places. So to talk a little bit about how influencers are regulated. We're going to go country by country on this one. So let's start by talking a little bit about the US, and then we'll move to China and country by country. We're going to try to keep this moving fairly quickly. So we're going to sort of go topic by topic and have everybody say a little bit. So bear with us as we try to move through quickly. In the US, we've probably got the most developed regulatory structure. Many of you may be familiar with the guide concerning the use of endorsements and testimonials from the which is under our general deceptive advertising law, section 5 of the FTC Act. It says that any material connection must be disclosed when the person who is posting has received, whether it's a payment, some sort of freebie, whether there's an ownership interest, if you're an employee, if you've gotten points, a coupon, even something as small as a sweepstakes entry, you have to disclose that if you're posting about a product or a company or something like that on social media. So it's a fairly restrictive standard. The Federal Trade Commission, state regulators, as well as our self-regulatory advertising body, the NAD, the National Advertising Division, all have been bringing many cases for quite a few years now, enforcing this standard. We've also even had other regulatory bodies like the Food and Drug Administration, the SEC, the Securities Enforcement Commission, interested in this issue and the idea of disclosure of material connections. The cases may be brought against the brand, against the agency, against the influencers themselves, and then of course all other standards applicable to advertising apply. So it must be truthful. Any statements must be substantiated, all that. The important thing right now is that the guide is actually currently under review. There were comments accepted last spring. The comment period has closed, but we're expecting some additional guidance from the commission, probably in large part a synthesization of what we've seen come out of cases over time, which is one way that the FTC develops its law. But one major change has been that the commission has gone from what was largely injunctive relief or conduct-based relief to asking for what can be very, very large civil money penalties or other money or property-based relief, asset freezes or the like. And so there's an expectation that that will be codified with this update. There's also some other areas where we're expecting changes. They did ask for comments about important areas like how people understand disclosures, so there may be some guidance on some more guidance like that. Children, self-regulation, and the like. So there may be some changes in that area coming up soon. So that's it in a nutshell here. I'll go on and let's talk with Justina about Chinese law.
Okay. There are no specific regulation for influencer marketing in China except for online promotion, online streaming promotion. As a result, the general rules of advertising, including those long standing content restrictions, applies for influencer marketing. Also, paid promotion should be labeled strictly as advertisement. The key regulators in China, including the State Administration for Market Regulation, National Radio and Television Administration, as well as some industry-specific regulators, such as the National Medical Products Administration, that is China's FDA. There's also a semi-independent industry self-regulatory body, that is China Advertising Association. For live streaming, the industry grows dramatically rapid over the past few years. More regulations have followed. In the last year, we have 2 regulations, that is guidelines on strengthening supervision of online live streaming marketing activities, and a circular on strengthening the administration of online show live streaming and e-commerce live streaming. These rules basically tie in with existing laws for enforcement purpose. Means violation can potentially result in very serious punishment of under the advertising law or unfair competition law. 2020 also saw the first self-regulation guidance from China Advertising Association on live streaming. That is a code of conduct for live streaming promotion. The code addresses live streamers, merchants, that means the brands, and platforms. The core principle is that transparency and full disclosure for the product or service promoted through online streaming is required. Of course, the code has no legal binding effect, but China Advertising Association is such a powerful body that can refer cases to the regulatory for further action or investigation. One more thing is the live streaming platforms in China that is different from in the States. We have Weibo, Weibo, and others, also tightening their own rules for live streaming and influencer promotions on the platform. They use suspension and bans as enforcement tools. That's what I'm going to share about China.
Okay, we seem to be missing Jose, so let's go to
Melissa. I'm here.
You're here?
I'm here, Melissa. I'm here. I'm sorry. I had some issues with my computer. I'm sorry.
I'm so happy,
I'm so sorry.
Jose. Let's
Thank
have
you, guys.
Mexico
Thank you.
then.
Yeah, sorry, I had some technical problems, but I'm back. So 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 I'll speak about my jurisdiction, which is Mexico, regarding how influencers are regulated. If you think that's fine, Melissa.
Yes, of course.
Well, in Mexico, we don't have a regulation that sees cases regarding influencers, but there's other laws and regulations that are part of how we can enforce those actions that influencers do in a day-to-day. So we have the consumer protection legislation, which is a law, obviously, for consumer protection issues. And there's a very important article there, which is Article 32, that talks about publicity, that publicity has to be verifiable, that publicity has to be obviously not misleading. And that's one of the biggest regulations that are that enforce, in a way, influencers, because obviously influencers are in a day-to-day publicizing, advertising in different platforms. So that's one of our regulations, which is the consumer protection legislation, which the authority is Profeco. Then we have COFEPRIS, which is the Mexican FDA. And many people will say, why the Mexican FDA? Well, the Mexican FDA has a section where they regulate certain products for publicizing the same. And obviously, if you don't have the permit from this authority, this product, there's a red flag that this product is, in a way, goes against all the sanitary legislation established in our jurisdiction. Just so you have an understanding about COFEPRIS, which is our Mexican FDA, during pandemic, more than 32,000 links or internet pages were brought down, because obviously it was people trying to promote products and even services that obviously did not count with a permit from the Mexican FDA, which is COFEPRIS, and the majority of those were influencers. Like, we know we have the big shot influencers, but we have other influencers that are moving in a day by day, and I believe they are considered influencers. Not because you have 2,000 followers, it's gonna be a difference, and you're not gonna be an influencer if you have 2 million. There's different markets. And obviously you can be an influencer. So that's for the Mexican FDA. Then we have obviously the Mexican PTO, where we could see cases of unlawful competition, and we have the tribunals. There's the civil tribunals for anything regarding moral damage, and we have criminal complaints before the FGR, which is the Attorney General's office, which we can be talking about defamation claims. And obviously we have self-regulations like CONAR, and unfortunately we don't have guidelines like in other countries. I would go to Peru, where the Peruvian PTO actually has guidelines regarding influencers. I think we have to push the authorities to get to this point here in Mexico. And well, this is like a little bit of perspective of Mexico, Melissa.
Excellent. And now I think we were talking to us about Sweden, and Erik.
Yes, hi. Thank you. In Sweden, there is no regulation specifically governing marketing performed by social media influencers. Instead, general marketing regulations apply. The primary regulation on advertising and marketing is found in the Swedish Marketing Practices Act. And this act provides general regulation on all marketing in Sweden. And it applies to all commercial communications, which basically means any means of communication that has a commercial purpose and is of a commercial nature. Non-commercial content obviously falls outside the scope of the Marketing Practice Act and is subject to each individual's freedom of expression. And the Marketing Practice Act includes, among other things, the rules on misleading marketing, but also which is of material importance for influencer marketing, of course, rules on marketing disclosure, which means that all commercial communications must be immediately identified as marketing, but also that recipients shall be made aware right away that there is a company behind the message. That is, must be disclosed who the advertiser is. We also have a regulator, and the primary regulator in this area is the Swedish Consumer Ombudsman. It supervises marketing practices, and it may issue orders or initiate legal proceedings against anyone acting in breach of Swedish marketing laws. The Consumer Ombudsman also publishes guidelines, some specifically targeting social media marketing, and such guidelines are not legally binding for courts, but they do reflect a current case law and illustrates quite well the regulator's interpretation of case law. And as such, I consider it of quite high practical value, since it gives you an idea on which topics the regulator finds crucial, and where there might actually be a higher risk of actual enforcement by the regulator. And the guidelines they cover subjects such as how to determine the difference between the commercial and non-commercial content, as well as how to make proper advertising disclosures. And they are a pretty good source for anyone doing influencer marketing in Sweden, I would say.
Does the ombudsman bring cases at all, or just publish guidelines?
No, it can bring cases as well. It's within its supervising powers.
Thank you. Hande?
Thank you very much, Melissa. Actually, like my colleagues in this panel from different jurisdictions mentioned, in Turkey, there are no specific laws relating to influencer marketing. There are no secondary regulations such as guidelines or self-regulatory rules either. So the general rules and principles of consumer law and the advertising regulation is also applied for the influencers, which means that their statements must be truthful and not misleading. They must comply with the rules regarding fair competition, public or moral values, etc. The rules prohibiting hidden advertisement are particularly important for influencer marketing. There is no specific law or guidelines about the disclosure requirements, but as a general advertising principle, ads must be clearly distinguishable, so the influencers must make it clear if there is a relation between them and the advertised brand. Additionally, influencer marketing can be categorized as a particular form of testimonial advertising. So the rules about testimonial advertising should also be regarded. As a rule in testimonial advertisements, testimonies or confirmatory statements that are not based on the real experience or knowledge or researches from the experts, institutions, or organizations must not be used. So if the influencer is sharing an experience that is fictional because of his or her agreement with the brand owner, this can be considered as a misleading advertisement, which is a breach of the general principles. In Turkey, the main authority to control advertisement is the Advertisement Board, which is established under the Ministry of Trade. As a general remark, I can say that influencer marketing is not a priority topic for the Advertisement Board unless the influencers are promoting health products. Health claims or health-related advertisement is a very sensitive topic in Turkey, in all media, and also for the influencers. And the board, the Advertising Board, pays utmost attention on this topic. I will talk about a few cases later, but I think this can be the general framework for Turkey can be summarized for the moment.
So it sounds like Turkey, they're regulating things in a similar way to the U.S., where the endorsements and testimonials rules and the general advertising laws are for deceptive and misleading advertising are used as well.
Yes, exactly.
But let's talk about then where the rubber meets the road, if you will, where the reality we see the reality of how these laws are used, which is the cases. Like I said, the FTC has brought a number of cases against influencers and against the brands that use influencers. The most recent, or one of the most recent, is FTC versus Teamy, which was March of last year, and it involved a tea brand, a health tea, and skincare products company that made claims about its tea that it treated cancer, that it helped you lose weight, decreased migraines, treated colds, all the good things that tea, of course, can do, at least the right tea. As you can imagine, the FTC was suspicious of these claims, but not only that, there was a wide range of influencers, including very famous celebrities like Jordan Sparks and Cardi B, and some very, very well-known influencers as well, such as Princess May, who were also making these claims, often without proper disclosures. And so the FTC brought a case, sent out many, many warning letters that alleging that there were inadequate disclosures being made on the post. Ultimately, the FTC settled with Teamy for $15.2 million, which represented the total sales of the challenged products, although it suspended that upon payment of $1 million based on their inability to pay the full judgment. This was, like a lot of the FTC cases, focused on primarily on Instagram posts, and the fact that the disclosures were not made early enough in the post, so that any disclosures were falling after the more, where the post that you could see on your phone broke off after 3 lines or 2 lines, and then you got more, and the post came after that. And that's been a real focus of a number of FTC cases on insufficiency of disclosures. So this was very typical of a lot of FTC cases you see. They focus on Instagram, they focus on health claims, on claims that are false and misleading, with insufficient disclosures. So there have been a number of other cases over the past few years involving things like incentivized reviews and even fake influencers at the federal, state, and self-regulatory level, but that's a great example case. So let's talk a little bit more about some of the cases in other countries, starting again with Justina in China. Oh, it looks like actually I have Mexico starting, so let's go.
Perfect.
Let's go to Jose.
Well, I just put this slide so you guys know a little bit about different cases that we had the opportunity to see in the past year, and so you guys can understand what authority is the authority that sees this kind of cases. So in first instance, we have an issue of consumer reviews. At the end of last year, a lot of people started saying that a cosmetic company was selling out-of-date products, and these out-of-date products were viralized. It was something that was turned on as a trending topic. So then there was influencers that were saying, well, the products are out of date. They could go against sanitary legislations. I didn't know about this, but this type of products never go out of date. So at the end, the case got to the Consumer Protection Agency because of the trending topic, and because there was a lot of influencers posting this type of information in the different platforms. The case got to the Consumer Protection Agency, and obviously at the end there was an agreement between both parties. But just so you can see the impact of an influencer in a day by day, just by putting a review of a product. So obviously this could have affected the company. At the end, it wasn't like that. We negotiated with the authority, and at the end, this was a case that was seen by the Consumer Protection Agency in Mexico, which is called Profeco. Then, in the second instance, we have the regulatory advertising. I was telling you in the past slide about the authorities that regulate advertising and publicity in Mexico, that our Mexican FDA, which is called COFEPRIS, has an area which regulates different kind of products, going from medical devices, tobacco, alcohol, different kinds of products. And if you don't have a permit from this authority, it's obviously a red flag that the product is going against all the sanitary and health laws in Mexico. So here is a case. You can see the donas in the bottom, which is a brand called Bimbo. It's the biggest bakery, I would say, top 5 bakery in the world. They acquired last year Sara Lee, which is what was one of the biggest bakeries in the United States. And if you see, there is the different black labeling promotions that you have to follow if you're going against regulatory advertising issues. So just so you can see a little bit how it happens in Mexico regarding that area. Then we have INPI, which I was telling you, it's the Mexican PTO. We had a case where an influencer was promoting an application where you could go, and it was seen so nicely. You could go into the application, and with that application, acquire a ticket, then go to the cinema you wanted. It didn't matter if it was Cinépolis, Cinemark, Cinemex, which is the biggest or the most known cinema companies in Mexico. But you could go into the app and go into the cinemas with a code scan. And at the end, obviously, they were using trademarks in the application without a license. So we filed an unlawful competition claim before the Mexican PTO. At the end, we did a discovery. We did discovery, and we noticed that the guy who did the application was a 15-year-old kid. And when we talked to him, he thought that we were going to bring him into jail. But just so you understand that the guy that did all this application didn't even know about the implications of doing something of this nature. This case could have gone not just to the Mexican PTO for unlawful competition, but it could have gone to the Mexican Attorney General's office for a criminal complaint, because obviously there was a copyright issue there. So this case was seen before the Mexican PTO, and FGR, which I was telling you is the Mexican Attorney General office. There is a case that started 5 years ago. Actually, it got decided last Thursday, where a very important attorney, who is a criminal lawyer, sued Google because in their platform, they were saying bad things about him. So he contacted Google and told him, please bring down all this information, because obviously this is not true. Google did not bring the information down. He sued Google for defamation, and the case was resolved last Thursday in the tribunal. It will get to the Supreme Court, but what I want to say here is that there's a precedent here where platforms are establishing that their servers are not in Mexican jurisdiction, and that way they are not liable for it. But obviously the authority is saying that they're liable. So it's something that is good, because it's a precedent that has established in Mexico. So those are some cases you have for Mexico. Thank you, Melissa.
Thanks. All right, Justina, can you talk about this fabulous case in China?
Thank you. I will make it quite brief. This is a very popular influencer who is an entrepreneur as well. So in this promotion, he promote some wool sweater from Pierre Cardin. And then it turned out it's totally fake. As you can see, the price does not match the brand value or the fabric at all. So instead of waiting for investigation from regulator, he turned himself to a whistleblower, report the case to the regulator, and claimed the manufacturer faked the license, from Pierre Cardin, and himself just pay 3 times of the purchase price for everyone who bought this sweater while watching the promotion online. That's the case I'm sharing. Thank you.
What would the penalty have been otherwise if he hadn't turned himself in? Was he just living with the guilt and he couldn't handle it?
Well, he is a quite famous entrepreneur, and he is a founder of some IT company. I guess there are 2 factors he considered. One is the liability that he may be facing as an influencer, needs to take joint liability with the manufacturer if they are promoting some fake products. And secondly, I think he does not want to damage his reputation. As you can tell, the price is really low. It's only 80 RMB per sweater. So 3 times is not such a damage to him at all.
That makes sense. It was not the typical situation. So, okay, thank you. Sweden, Erik, tell us about this case. It looks very interesting.
It is. Thank you. Well, as I said before, the Swedish regulator is the consumer ombudsman, and it has actually brought several influencers to court during the last years, and an increasing number of cases also appear before self-regulatory bodies like the Swedish Advertising Ombudsman. But still, the real issue that is cases initiated by the regulator, because I mean they can trigger legal sanctions such as conditional fines, market disruption fees, and damages. Self-regulatory bodies like the Swedish Advertising Ombudsman can't impose any sanctions, but the main implication would be decisions showing providing potential bad press or bad will or similar. And there is a key case in Sweden which concerns Kinsa. She's appearing on a screen before you, I believe. And she is a very famous and successful Swedish influencer. And in the case, the Swedish Consumer Ombudsman challenged some of Kinsa's posts that appeared on different social media platforms such as Instagram, Facebook, her blog, etc. And the argument were that the post was lacking proper marketing disclosure. And the posts that were challenged, they contain content that Kinsa had published in connection with a trip to Zanzibar. And the trip was paid for by a brand that Kinsa had a collaboration with. And during the trip, Kinsa published several posts that referred to the company's product. And the main issue for the court to decide was whether all of Kinsa's posts constituted marketing, or if some were editorial content simply providing the view or personal opinion of Kinsa. The regulator argued that all of the posts made in connection with the trip were made within the framework of Kinsa's collaboration with the brand, and as such, it was marketing carried out for the brand and should be disclosed as marketing. Kinsa, on the other hand, she disputed the claims and arguments of the regulator, of course, and argued that not all, but some were part of the collaboration. And the court eventually reasoned that, well, in order for an influencer's social media post which shows or recommends a company's product to constitute marketing, there must be an explicit or at least an implied agreement which includes some kind of compensation between the brand and the influencer in relation to a particular post. And the compensation, however, it can be monetary or consists of products or compensation, like in the case at hand, a trip that was paid for. And considering the facts of the case, the court found that the evidence supported actually that only a few of Kinza's posts were actually stipulated by the agreement between Kinza and the brand. And consequently, the court concluded that only 3 posts were evidently made within the framework of the collaboration and therefore considered marketing on behalf of the brand. And only these 3 posts required marketing disclosure. The other posts, they were considered editorial content, showing only the individual view of Kinza, and this regardless of the existence of a general agreement of collaboration of certain marketing services on a general level between the parties. And as a result, the influencer was cleared with regard to most of the posts that were challenged by the regulator. But the court found that those posts that were actually considered marketing, they had not been properly disclosed in accordance with the Marketing Practices Act. Because these posts, they had only, I think in 2 cases, vague references to collaboration with a brand or something. That was the only disclosure at all. And the remaining of the 3 posts, it had no disclosure at all. So, well, the influencer was ordered to cease with such marketing subject to a conditional fine. And I would say that the key takeaway from this case is that when engaging an influencer in Sweden, you need to be, you should really consider where to be very specific in any agreement with the influencer, which publications actually falls within the scope of the collaboration. In that way, you can probably reduce the risk quite a lot. Thank you.
So you only need to disclose then, Erik, if it's a post that is specified by the agreement?
Yeah, or well, the agreement can be explicit or implied, of course, but the regulator must be able to establish or show that a particular post is covered by an agreement.
Okay.
Otherwise, it falls outside the obligation to disclose.
Okay, thank you. All right, last case.
From Turkey, yeah.
Turkey.
Yes, well, as I mentioned, actually, the influencer marketing is not a hot topic for the advertising board unless there are health claims. As this issue is a very, very sensitive issue for the board, the influencers are also under a strict control of the board. Last year, the control was enhanced because of this COVID-19 pandemic. There are 2 cases I would like to mention. The first one is not the one on the screen. In the first case, a famous model presented a food supplement, which she claimed that it was the source of her energy in the morning, without any disclosure about the relation between her and the brand and the product owner. So the board decided that this is a hidden advertisement. No monetary sanction was imposed, but the social media post has been removed. In the second case, which is more significant, as the board also imposed monetary sanction against the influencers. In this case, many celebrities posted videos from their social media, one after other, about a product called No Attack. On the screen, you are seeing some of these celebrities. This was just after the first cases of COVID-19 showed up in Turkey, and these celebrities claimed that this product protects them from the effects of coronavirus. Considering the current situation all around the world, it was obvious that this product, which was a food supplement, had no such effects. So the advertisement board immediately acted against these advertisements and stopped them and imposed monetary sanction against the brand owner. And normally, only the advertiser, the brand owner, is imposed monetary sanctions. But in this case, each of the celebrities were also imposed monetary sanction. The amount of the fine is around 10,000 euros. This may not be a big amount for these people. But this was a clear message to the influencers that they must also be careful about their social media posts.
Interesting.
Yes.
All right, let's discuss disclosures and best practices. One of the difficult things with some of the multi-country programs is that, you know, what disclosures do or don't work in a specific country may not be the same everywhere. So let's explore a little bit what disclosures do or don't work in your country, what's sufficiently clear and conspicuous, also what expectations are there for things like monitoring, for influencer compliance. Will the brand even be liable if the influencer doesn't comply with the law? And then are there any expectations if an influencer isn't complying and making proper disclosures that a brand must enforce and say, hey, you know, you must, you need to go fix this. In the US, for instance, as I mentioned before in the TIMI case, the FTC has been very active when it comes to enforcing expectations that on Instagram, you must disclose before the fold. The same goes with other platforms where on mobile, you might break up, the nature of mobile may break up those disclosures. There's been a lot of guidance from the FTC about whether certain disclosures will or won't work. #ad, it's 3 characters, it'll always work, is sort of the position from the regulator, but thanks won't work. It's not a sufficient indicator that something of value was received by the influencer. If you go to the FTC's webpage, there's guidance in the form of FAQs about disclosures that will or will not work. We've also gotten some recent guidance about things, newer platforms like Snap, where we've said, oh, gee, it should go in the picture itself because of the nature of the platform, or even from our self-regulator, we recently got guidance that on TikTok, you must have it not in, it must be right in the TikTok, a visual disclosure, because that way the disclosure will travel with the TikTok as it's shared to other platforms. So, you know, we have gotten guidance like this as to specifically what kinds of disclosures will work and how to make them in a way that will always show up on your phone as well as online, and what will be clear and conspicuous. The idea that one size won't necessarily fit all, either in terms of the platform or in terms of the relationship. You know, #free may be better, but if, you know, if what you're getting isn't free and it's actually a payment, that's not going to work because that's not truthful. So, you know, you've got to make sure that your disclosure is truthful, as well as clear. So these are the types of things that we've been considering in the US. Additionally, there's been communication about the fact that the brand is liable. An agency can be liable as well if an influencer does not comply. And in fact, there's the expectation that the brand hiring the influencer must both train its own people to make sure, and its agencies to make sure that the influencer is compliant, and then monitor influencer compliance and enforce if it finds that the influencer isn't complying, and even terminate if it consistently does not comply. So that was actually part of the compliance order in the TIMI case, was that TIMI is expected, if it hires in the future, to monitor and enforce against influencers who don't comply. So what kinds of expectations are there when it comes to disclosures or other best practices in your country? So let's talk a little bit about this in a few of the countries. For time purposes, we may start skipping around a little bit and not addressing every country. But let's start with Mexico and Jose.
Hi, Melissa. Well, regarding disclosures, like I mentioned before, we don't have any guidelines or any regulations regarding influencers. But I would say best practices. When we sit down with influencers, we try to do a thorough clearance regarding what they're gonna be uploading and what they're gonna be publicizing and advertising. So I think that's very important. And obviously, the contract that the influencer celebrates with the trademark, with the brand, and with the company that they're going to be promoting, I think it's very important. But to be honest, everything comes down to a contract and to contract between parties regarding who is liable. Maybe if there's an issue on legal standards done by the influencer, it has to be very well established in the contract. But regarding disclosures, at the end, like I mentioned, like we don't have any regulations or any guidelines. So whatever the influencer is disclosing in a day by day, I think he has to adapt to a contractual issue with the company they are having a relationship with, so they can be very covered in a way. One example was there was an influencer, and we were talking this in last week in our rehearsal. There was an influencer that wanted to do a live promotion of the Super Bowl, and he was using trademarks all over the place. He was using the names of players, and we told him, you can't do this because obviously you don't have the right to use a trademark that is not used. It's not yours. So at the end, the influencer did not disclose anything. At the end, he thought it was going to be like a blockbuster, but obviously it wasn't, because he was infringing a lot of IP issues, some actually ethical issues, and you have to guide them in a way for them not to be disclosing about things that can go, first of all, against intellectual property rights, obviously ethics, things regarding sexism. So I think the most important thing in our jurisdiction is to do a thorough clearance to what the influencer will be disclosing in a day by day, so they can be so they don't have any issues. And obviously the big thing here is the contractual arrangement between the parties.
Right, Erik, let's hear about Sweden.
Thank you. Well, the liability in Sweden, it can exist for basically anyone concerned. The primary liability lies with the advertiser, but anyone who has substantially contributed to advertising, such as an influencer or even an agency connecting an influencer with a brand, could be held liable. The Marketing Practice Act does not provide an exact course of action on how to make disclosures, but the disclosure can be provided in different ways, and depending on the context, type of media, recipients, you may have to take different actions. The overall requirement, of course, is that the disclosure must ensure that an average consumer immediately understands that the content is paid for. And you may then have to adjust the content if your targets are part of a specifically vulnerable group, or if they're minors or the like. Circumstances that has been recognized to contribute to proper disclosures are explicit disclosures using non-ambiguous words such as advertising, marketing, or paid collaborations. However, if you use ambiguous words or unclear words or hashtags like collaboration or in collaboration with, ambassador, or simply state thanks or something, which that doesn't necessarily imply that there is a paid relationship, and those kind of ambiguous words should be avoided. And you also need to make sure that your disclosure is presented in the beginning or above the fold of any post, making it visible right away for anyone viewing the communication. And this is probably the most important practice to remember, since if you neglect this, this will usually render all other measures for disclosure futile. Because disclosures that are made only in the end of the post, such as the end of an Instagram caption or hidden among hashtags or something, will usually not work. Another important thing to consider is to make sure that your disclosures are made in a text or color that distinguishes it from distinguishes the paid content from editorial content. So don't use small fonts or disclosures in smaller text than the rest of the post or message. And you should also be consistent by using similar marketing disclosures for all your paid posts, such as the same fonts, colors, etc. This will make it easier for you to argue that a proper disclosure has actually been made. And what's more, you need to also make sure that the brand that has been marketed and who is responsible for commercial message is identified clearly. And if the brand in question is well known, or well, then you can usually rely on simply putting a trademark or make reference to that. There is no requirement to monitor your influencers, but since a brand is liable for marketing that an influencer carries out on its behalf, monitoring actions in order to ensure compliance is of course advisable. And since both the brand and the influencer may be liable under the Market Practices Act, it's also in both parties' interest generally to be accurate and correct any inadequate disclosures.
Okay. On the next question, we'll have the women answer. On influencer agreements. Are influencer agreements generally required? And what types of clauses do you generally recommend for an influencer agreement? So here they're generally used, but in terms of complexity and what's included, it tends to be a little all over the place depending on what type of influencer you're using and the sophistication. Certainly you want at least a representation and warranty about compliance with the endorsements and testimonials rules, but and you know a termination clause in case they don't. But from there, you know, you want a morals clause in case, you know, your celebrity influencer goes off the rails. Intellectual property, so you have some rights to repost, exclusivity, you know, these types. How much do you actually want to attach an influencer policy to make it clear what types of requirements there are? So what types of things do you want to include in your country? Let's start with Justina.
There are no compulsory rules for this kind of agreement, but agents quite a rising presence in China. Lots of influencers go through agent, but some of them still not. I think when talking about the agreement with influencers in China, certain things like the calculation of promotion fees may need to be discussed, because last time, if it is live streaming promotion connected with sales on e-commerce platform, the influencer may want to share a portion of the sales amount or other parameters. Also need to pay attention to the exclusivity, such as whether the influencer has an exclusive agreement with agents, then you have to go through the agent for any agreement with them. Also, if whether you like to put on exclusive deals with specific influencers for promotions brands. Generally, we see for women's clothes and accessories, there are quite a few deals on exclusive basis. That means the competitors cannot use the influencer for their products. Other things like influencer behavior is quite important as well. within influencers that is conduct unethical or illegal behaviors, basically blocked from mass medias, and no brand should go to such influencer for any promotion deal because basically they cannot post anything online, and if it is posted, it might be blocked. Of course, you would like to put it is advised to put it in the agreement that the influencer has to have a good behavior, and the brand has a right to terminate the law if any extreme thing happen. That's I'm going to share. Thank you.
Okay, Hande.
Yeah, thank you. Actually, for the sake of time, I will not repeat all the things that Justina has said. They are also valid for Turkey. So actually, in addition to the general clauses that you would use in a standard service agreement, you should also, you must clarify the extent of creative discretion of the influencer here. Actually, as Justina mentioned, the influencer's behavior. And also the influencer must be warned for the risky subjects so that they can be aware about these risky areas while posting content on the social media.
You gave me a great segue, Hande, because our next slide and our last slide is on hotspots.
Yes.
We talked a little bit about these throughout the presentation, but there can be real variations in what a regulated hotspot might be, although there are lots of commonalities. We talked in one of the earlier panels about some of the issues with discrimination and the like that may be regulated in some jurisdictions and not so much in others. What are risk areas in your jurisdiction? For instance, here in the US, we've had several cases involving kidfluencers who did not talk about the fact that they were being paid to unbox toys and open them up with many oohs and ahs. And lately there have been lots of COVID cases where there were false claims, lots of warning letters, a few takedowns, that sort of thing. So what are big issues in your jurisdiction? Let's start with you, Hande.
You said Hande, am I correct?
Yes.
Yes. So actually, the risk areas that you summarized here are also the risk areas in Turkey. There is a total ban of advertising for tobacco and alcohol products, for drugs and pharmaceuticals, and influencers are not allowed to advertise this category. Other than that, as I underlined during this session, health claims are quite sensitive in Turkey. So the food supplements is also another area that must be treated very carefully. There is no prohibition for food supplements, but it is a very sensitive area. Also, the ads featuring children or ads targeting children are also quite sensitive issue in Turkey. We don't have a kid influencer so far. Usually mummies do the advertising for them, but this is also an area that must be treated carefully.
Jose, you're back. You want to say something?
Yes, Melissa. No, I'm always here. Don't worry. In Mexico, like I mentioned, regarding health claims, food, drug, cosmetic claims as well, alcohol, tobacco, it goes and it's regulated by COFEPRIS, which is the Mexican FDA, like I mentioned. So you need an actual permit from this authority to publicize this type of products. Regarding kidfluencers, we have 2 or 3 who are well known, and obviously they're regulated by the different legislations that I've told you in the past. Obviously, Mexican consumer protection law, the health law. Obviously, there's unlawful competition issues there, but this, like you mentioned, it's a hotspot, and it's risky areas because you have to be very careful on doing a thorough clearance to see if your product is being considered a health claim, or obviously if you're talking about sexism and discrimination, well, obviously, what is the thin line between sexism and discrimination? I think that's very important to mention it, because obviously I think it's a very subjective topic, but in a way, the hotspots regarding health claims, food, drug, cosmetic claims, alcohol and tobacco are regulated by our health authority, which is COFEPRIS.
Okay, I'm told the code word is on the next slide. Whoops, except I'm going to skip through it. The code word is disclosure. Disclosure. I like that. So, and the last, this is just a wrap up, and then we are finishing up. So things in terms of practical considerations, of course, we're all doing these global campaigns. I think this has been discussed a little bit before earlier in the day, but you know, in thinking about these global disclosure campaigns, you need to think about issues like when will a regulator even bring a case against you as the advertiser when you are targeting consumers in other countries, or even just, you know, you're online, your campaign may be available in other countries. You know, the regulator may look at, are you targeting consumers in that country? Is it in the native language? Do you have a physical presence? Or even just servers in that country? Do you have stores, offices? Because if you may be regulated in one of these countries or one of our other GALA member countries, then you may be triggering things like translation requirements, not just for the campaign, but for your privacy policy or for your terms and conditions. You may need to think about things like variations in taste or customs or perception or hotspots, or all sorts of other considerations. So I hope you enjoyed this, and thanks so much for visiting with us.